I got two crimes being levied against me. I got a court date in July. And I want to start out with the one that they were turning to the most. Although it did start out more with possibly trespassing. Sounded like they were leaning on verbally telling me that I would get charged with obstruction first. So I'll start out with that first. And I highlighted some things. Let me just scroll down to the bottom here. I highlighted a few things here, including a ChatGPT analysis in a different color. This green color is what the city has written. They are the 58-2. Alright, so they write their own codes for the municipality, for the city. In this case, though, they have chosen to just go with the state statute, and instead of just saying, we will go with the state statute, they wrote all this huge paragraph talking about future and past, and let's see, current or future, prohibited or accepted, revisions or modifications. Like anything that changes within the state statute, they're just trying to. They're saying that they'll be changing as soon as the state statute changes. So that's this 58-2 part of it, and somebody had to point this out in the comments. Then you get into 946.41, which is the Wisconsin statute 946.41. So I was confused because I looked up the whole thing, 58.2, 946.1, and I was looking for the whole thing in its entirety, and it's just not there. You find it in two spots. First, the ordinance, and then you got to look up the statutes. You got to kind of know this stuff for Wisconsin. So, getting into the state statute now, it's 946.41, resisting or obstructing an officer. I grayed out some things I don't find to be too relevant to me. Let's see. Knowingly resists or obstructs an officer while such officer is doing any act in an official capacity with legal authority is guilty of Class A misdemeanor. In this section, no, they're saying obstructs, and I graded a little bit. Includes without limitation knowingly giving false information to the cop, or knowingly placing physical evidence with intent to mislead the cop in the performance of his duty, including the service of any summons or civil process. I just don't see how that's relevant to me. Officer, peace officer, a public employee having the authority by virtue of the officers, and see, they misspelled employee here. And this is copy-paste. I copied exactly what they got. Maybe the original document has two E's. Employee's office. But that's what concerns me, though, is that if they're going to misspell words, it's going to kind of corrupt the interpretation of it. Because they misspelled it twice. Employee has been misspelled twice. Public officer or public. So they're saying, with the distraction of the bad spelling, they're saying that public employees are allowed to arrest the public. They're allowed to walk around with handcuffs and arrest people as they see fit. Has this been exercised? It would be interesting to see some case examples. But I find that a little disturbing. I don't feel that this whole grayed out section has any relevance to me, so I'm not even going to read it. I turned yellow things that look like a good defense. Now this is copy paste from their statutes, the state statute. They've applied some references to court cases in here in their statutes. I never really noticed other states doing that. Actually putting court cases in their statutes to refer to. That adds more words, but I mean, that's what the lawmakers are doing. The lawmakers are adding court cases into their statutes as kind of a footnote. Actually, I think these court cases were in a smaller print. Everything's the same print on my screen. State must prove that the accused new officer... Okay, I'll go with the yellow. Yellow is the most relevant. Defendant's refusal to identify self did not obstruct officer. You know, it's pleading the fifth, pleading the fourth. So that's, I mean, that's in the statute. Yet I'm still getting charged with this? No law allows officers to arrest for obstruction of his or her name. Mere silence is insufficient to constitute obstruction. Hennes v. Morrissey in 1995. Right there. I mean, I'm asking the cops for their names. That's pretty much being silent. I'm willing to exchange names. They go first, I go second. They can't do that. They're violating their own law. They're what they believe to be their own law. Actually, they're operating under a set of different laws apart from what's actually written. And I mean, if officers are going to cite false constitutional rights, saying the Fourth Amendment is a right to bear arms, then they're going to have trouble with this. Now in this color, all throughout, this is the ChatGPT analysis of the statute. I said, find flaws in this statute. There can be inconsistencies with mens rea about the knowingly. I argue that civil liability, that's not really that relevant to me. The civil stuff, I mean, it sounds like they can... that's why the officers that arrested me, they are talking about how it's just a municipal charge and not a criminal charge, and they're causing some confusion between civil and criminal, and that seems ridiculous to me. I mean, if cops are involved with this, it's just my case. It's looking more criminal than anything. Overbroad historical cases. Historical cases support me in my defense. Mere refusal to identify oneself is not considered obstruction. So there's a difference between silence and providing false information. Okay, and that was obstruction. Now I'll go to loitering. We go to the top. Now this is the statute. I could find this in the municipal ordinances. No person shall loiter in a manner not usual for law-abiding individuals. That's a little strange to read. Under circumstances that warrant alarm for the safety of persons or property in the vicinity. Among the circumstances which may be considered in determining whether such alarm is warranted is the fact that the actor takes flight upon appearance of a police or peace officer, refused to identify himself, or endeavors to conceal himself. Unless flight by the actor, other circumstances make it impractical. Let's see. I think in between actor and other, I think they mean or other. Alright? It just doesn't read right to me reading this. And they're clearly demonstrating that they're bad at spelling. They're bad at grammar too. Unless flights by the actor or other circumstances make it impractical. So it just doesn't make sense if it's just actor or other. I think they're poorly writing their laws, and then that leads to poor interpretation as well for the village of West Milwaukee. Because that's so weird. And does nobody question the lawmakers on their writing, or whoever's in charge of writing the law? Does nobody question them? So they're saying there could be other circumstances making it, and in ChatGPT down below points out that it's still, they read through, they knew that there should be other, they didn't point that out. They don't point out spelling and grammar. Maybe if I asked the AI to make spelling and grammar errors, they might actually point it out. They just kind of read through and assume other and or was there. But other circumstances open up a lot of open-ended, broad, vague circumstances, other vague circumstances to make it, what they say, impractical to dispel any alarm. All right, there's a lot of circumstances that make it hard to dispel alarm. But in my case, we were fully conversational the whole time up to my arrest. I would be interested to see what kind of circumstances that the officer would want to bring up later. They like to do that. They like to bring up different arguments later. Afford the actor an opportunity to dispel any alarm which would otherwise be warranted by requesting him to identify himself, explain his presence and conduct. No person shall be convicted of an offense under the subsection of the cop did not comply with the preceding sentence. Well, I mean, I hope they write a report and explain what they were thinking at the time of the arrest. I mean, this is an arrest, so there should be an explanation of that. I have to ask for on Tuesday. Appears at trial that the explanation given by the actor was true, believed by the police. But I don't think that's, even though whatever I told them, I don't think that was a cause of consideration for them to reject or accept. I don't think they reject. I don't know if they. It's hard for me to believe they rejected my explanation for being there. It just seemed like they just wanted to arrest me over my ID and nothing else. Because they can reject any explanation by just saying there were other circumstances. And it's mentioned here in the ChatGPT response. There could be scrutiny, the vagueness. I mean, we don't. I mean, okay, maybe the term loiter is explained later at the back of the ordinances. I didn't actually look at definitions. That's something that I have to do. Maybe they explain what loiter and prowl means to them. So there's the vagueness there it was short of me having actually looking at. You know, I probably could have just put in all the statutes for the city into Gemini or ChatGPT and then analyzed it that way. Just say analyze this particular law, and it might have picked up the definition for loiter if there was a definition, and then they wouldn't have made this vagueness argument, possibly, because the AI seems to find everything relevant pretty quickly and efficiently. The determination of whether circumstances warrant alarm for the safety is highly subjective. Arbitrary enforcement is a problem. Discrimination, something to marginalize communities. Constitutional concerns, I'm not obligated to give up my Fourth Amendment or Fifth Amendment rights. Opportunity to dispense alarm. The requirement a police officer must afford an actor an opportunity to dispel alarm before arresting them as a safeguard. But the clause, and look at that, even quotes, unless flight by the actor, other circumstances, and it's actor or other circumstances. So ChatGPT has recognized that, but they're just saying that it can still introduce ambiguity. It might be argued that officers could use this exception too liberally. And that's what I was saying just at the point of where the law was stated. This ChatGPT points out that it's a little too open-ended when they put or other, or I mean when they put other, but I mean it just doesn't read right if they don't have or in there. Burden of proof, okay. The standard, yep. Overall, the law aims to address legitimate concerns about public safety, its vagueness, subjectivity, and potential constitutional issues. You see, this isn't like having a law that says all dogs must be on leashes in the park. That's pretty obvious, or I mean, pretty clear. But when it comes down to loitering and resisting arrest or whatever, obstruction of justice, then there's a lot more gray area.